Folks, something very, very big just happened in the world of FPV and the world of drones in general. The lawsuit between Race Day Quads and the FAA went to oral arguments in front of the United States Court of Appeals for the D.C. Circuit. In other words, the lawyer for Race Day Quads was grilled by judges who will decide whether the FAA can go forward with their remote ID or whether they need to do something different. And the FAA lawyer was grilled too. And that's what we are here to talk about. I'm here with my co-host. It's Blunty. Blunty, thank you so much for being here.
Yeah, happy to be here. Happy to take a look, a deep dive.
A deep dive.
On the DC appeals case. I think this is pretty exciting because I think we wanted to know for a while, how the courts feel and where everybody's at, what the FAA's stance is when they get talked to and asked a bunch of questions. So it's pretty exciting.
My name is Loretta Alkalay. I'm an aviation attorney. I worked for the FAA for 30 years. I was head of the legal office in New York. We handled enforcement cases, all kinds of litigation. And now I'm an adjunct professor at Vaughn College of Aeronautics. I teach drone laws, among other courses. And I also do consulting, things like that. Jonathan Ruprecht and Kathy Yotis are both friends of mine. And I think that RDQ and Tyler picked excellent attorneys. And I think Jonathan did a fantastic job. I think the DOJ attorney did not. But I think what's most interesting is the reactions of the three judges.
Case number 21-1087, Tyler Brennan and Race Day Quads LLC petitioners versus Stephen Dixon, administrator, and Federal Aviation Administration. Mr. Ruprecht for the petitioners, Mr. Ross for the respondents.
My name is Jonathan Ruprecht. I am the attorney for the petitioners. I am also a commercial pilot and flight instructor. Today, we asked this court to vacate the FAA's rulemaking and send it back to them. Two reasons why. One, the regulations are a violation of the Fourth Amendment. And two, the rulemaking, it was arbitrary and capricious because the FAA failed to respond to many significant comments. As to the first point, the Fourth Amendment violations, people have a reasonable expectation of privacy in their backyards. And remote identification allows for law enforcement to track individuals in their backyard. With remote identification here, law enforcement, without any warrant, and it's completely unlimited, are allowed to track an individual in his backyard.
Wait a minute, Mr. Ruprecht, you're getting a little bit ahead of the rule. The rule does not create any authority for law enforcement to access any information.
The rulemaking was specifically done in such a way so that there is no, it allows for anybody with a wireless electronic device, such as a phone or a laptop, to be able to actually receive the information that's broadcast. So it's public as well as law enforcement. So the states, the federal agency, law enforcement agencies, as well as the local law enforcement agencies could all receive this information.
You say could, but isn't there a need for some further authorization, enabling? I mean, they're requiring the drones to have this broadcast capability, but they're not opening access to the results of it under this rule, are they?
Blunty, this is confusing me a little bit because we know that the rule as written requires you to have this broadcast module, unless you're flying at a FRIA. But in general, for most flights, you would have to have this broadcast module, which is simply broadcasting this information out. And again, according to what they wrote, it could be picked up similar to Bluetooth or Wi-Fi by a cell phone. And it's odd to me that the judges are, it feels like there may be some wording in the law or something. I don't know. Are we missing something here? Am I missing something here?
Well, I think they're trying to make the differentiation between personal information and public information. Because your drone's location, if your drone is visible, like above a tree line or somewhere like that, is public information. Versus your drone under a tree line or somewhere like that is private information, or so as the FAA understands, it's still public. And that's part of where they get into later in this conversation. But it seems to me like the probing here is them talking about what information are you actually getting? Don't you need to have like some system of record set up, and then the FAA has a records notice filed for that information that they're going to access when they identify your serial ID with the information they have in the FAA database. And that's when the two things are linked, or when you're actually like identified as a person other than just your location that can be seen from an outside perspective. That's my understanding of what's happening.
You're making an argument about what's broadcast publicly. That is broadcast without identifying information, correct? Of the operator.
Correct. For purposes of the actual message element, it's a unique serial number ID that's going to go out. And so that information, everybody can get it. The systems of record notice on FitNet 4, when they talk about it, that is specifically what's going to happen is going to be correlation.
Okay, but my point is, for Fourth Amendment purposes, your argument would then be that receiving real-time data that does not identify the operator of a drone is still nonetheless a search within Fourth Amendment purposes, right? That's your argument?
Yes, Your Honor, because specifically, even if the law enforcement did not have was not unable to actually real time right then and there actually log that information into the databases and actually see the airman record, specifically what we've indicated in the addendum, you can see that there's medical records that are actually indicated there. We can see people's eye color and their weight and their hair. So setting aside they didn't have access to that, it allows for the logging and aggregation of this data. And then all you have to do is just pair it up. Public property records. Now I know exactly who lives there based upon public records. And I've seen that unique serial number. It's not randomized or anonymized. It's a unique serial number that traces around across the United States. You log it, and then you can go back and actually search the archives.
So we're coming now, I guess, to the end of Jonathan's questioning. It seems like the big thing that they're focusing on with Jonathan is race day quads, is that his Fourth Amendment argument may fall apart if the link between the person and the publicly broadcast identifier is protected in some way. That seems to be what they're sort of angling at. And his argument is that if the unique identifier can be aggregated, it can result in a violation of your Fourth Amendment privacy rights.
Yeah. What I think is interesting is that although those are the cases, and that's what we see here, I think that he talks about the distinction between the two pieces of information, the public broadcast ID, which, as far as I know, will be randomized in some fact, so people can't do that identifier. But then there's also the private piece and who has access to that and what system records notices have been filed and what will be filed, which is where the judges kind of push it once they start questioning the FAA side of it. And I still think there are a lot of legs there. They're just in different places than we expected them to be.
We'll hear now from Mr. Ross.
I'm going to get my scowling face on.
Thank you, Your Honor. Thank you, Your Honor. Kason Ross for the United States. Following Congress's prescription to establish rules allowing for the remote identification of unmanned aircraft systems, the agency issued the rule challenged here to allow for airspace awareness, to distinguish compliant airspace use.
I hate this guy already. Smug. Listen to how smug he sounds. Okay, I'm sorry. We'll continue.
Users from those that may pose a security or safety threat.
So is it the FAA's position that it can regulate down to the ground and over private property?
The judges did ask about that. What gives the FAA the authority to regulate to the ground? And I don't think the Justice Department attorney answered that particularly well. First of all, because I personally don't feel that it's that clear. I know that it's something that a lot of drone, especially commercial drone operators, don't want the court to decide because that could leave open regulation to state and local governments. But I think that the way the court, the two of the judges were leaning anyway, it looked like a Fourth Amendment issue, in which case, if the court ruled that it was an invasion of privacy, violated the Fourth Amendment, then state and local governments wouldn't be able to regulate that. If they decided that the FAA didn't have the authority to regulate down to the ground, then arguably state and local governments could step in.
Yeah, I think there are some people who would argue that race day quads is playing a little bit of a dangerous game here in that they are opening the door to the Fourth Amendment argument, which we would love to win. That would be great for everybody, for us, for drone users, and this private airspace argument, which if the judges were to latch on to that and say, you know what, the FAA can't regulate down to the ground level, private airspace is a thing, and then we'd have this local cities, counties, states regulating, and you'd have this patchwork of problematic regulations, some people would argue. Do you have more thoughts on that?
Well, I'm a strong believer in property rights. So I mean, if I have to choose between property rights and drone rights, I'm in favor of property rights. So I do feel that we can't have a patchwork of rules in certain airspace, but I don't know that that's the case for your own property below a certain altitude. I mean, I'm not looking forward to Amazon delivering to my doorstep unless I authorized Amazon to deliver to my doorstep. So, I think a lot of people in the drone industry kind of poo-poo property rights, but I think that's a mistake.
So is it the FAA's position that it can regulate down to the ground and over private property?
This case doesn't raise that question, Your Honor, and petitioners' arguments to the contrary in their reply brief are not worth addressing in this case. But instead, it's the regulation at issue here was simply pursuant to the regulation of air commerce. And courts that have addressed this question, which we didn't raise in our brief.
Let's say we rule for you in every respect.
Right.
Down the road, could someone bring an as-applied challenge on Fourth Amendment's ground to the FAA's tracking someone's use of a drone on their own property, particularly when the drone is on the property below them?
And let's suppose that there's just no enforcement action at all. So it's not even a defense to an enforcement action. It's just that somebody a year from now buys a drone and they want to just use it on their 100 acres in the country. And that's the only place that they want to use it. And they don't want to have to transmit their remote ID data to the government. How can they bring that challenge?
I think at that juncture, Judge Wilkins, absent any other government action, they wouldn't have the ability to do so. Congress has channeled FAA's or challenges to FAA rules to be within the 60 days the rule is promulgated. So unless the agency takes some sort of enforcement action against that ranch owner, I don't believe they would have any ability to challenge it a year from now.
Then what is the government interest in obtaining remote ID data from a drone that's operating entirely on one's property?
Because, Your Honor, it's easily foreseeable for the drone to be operated outside of that person's property.
I mean, there's lots of ways that this could have been written more narrowly. I recognize that isn't the rule we have, and this isn't actually the nature of the challenge even that we have before us, but we're just probing the interest of the FAA behind this particular rule. And it does seem difficult in some fact situations to correlate the interest that you've stated and that we see in the administrative record with some of the applications.
One of the things that I like about this is that the judges are asking questions about other ways that the rule could have been worded to grant more liberty and freedoms to drone operators. The FAA's position seems to be, everyone needs to do this everywhere. And people are like, well, what if we had some conditions where we didn't have to do it? And they're like, no, too hard, too difficult. They're not going to do it. And I like that the judges are saying, well, what if you were under a tree line? Why couldn't you design a system where you said, if you did it that way, then you'd be in violation?
For whatever reason, in this case, it struck them. Well, I mean, for obvious reasons. I mean, I think that the regulation is way overbroad. I think that, as many people think that some kind of remote ID is going to be required in some circumstances, but many of us felt that regulating down to people's backyards below the treetops was the most egregious overreach.
Yeah, part of the problem too is he uses this idea that the FAA has been regulating airspace and they understand how to regulate airspace and they can deal with this, but nobody owns private airspace like that. Like maybe large different places have permissions to those airspaces, but the idea that they're somehow regulating all these people's private airspace doesn't happen. And now you're trying to regulate private property, which is kind of the conversation here. And you can't apply the same rules that you're applying to this public airspace to private property.
I think that some of Jonathan's arguments that the court did not seem to either grasp or pay that much attention to is that even without the correlation with the FAA database, you're basically tracking people in their homes or on their properties. And even though the DOJ attorney indicated that that information was not going to be maintained, I don't believe that that's correct. I think that once that data is created, I think the FAA and law enforcement will go back over days, weeks, months, and years. So what Jonathan argued in the brief was that in and of itself, the ability to track someone over an extended period of time was an illegal search.
Now, the thing that I worry about here, though, is that they're very focused on this concept of private airspace. And it's not clear to me whether that is being used as a general example of a way in which you hypothetically might change the rule, or whether they specifically are in support of the concept of private airspace, because there's all kinds of problems with the idea of private airspace.
Yeah, absolutely. It's tough because there is a lot of talk in here about that concept directly. So, I think, like we've talked about before, we definitely have to see the briefs and where everything lands when their statements come out from these judges. But I would not be surprised to see some kind of response like that.
I think they had very pointed questions for him, and I think that, to me, indicated that they had real concerns with regard to the Fourth Amendment. And a lot of people were pontificating that courts avoid constitutional issues and they're not going to want to talk about the Fourth Amendment. But in this case, at least two of the three judges had pretty pronounced concerns. So you never know how the case is going to go based on oral argument. But one of the judges did actually say that it was unconstitutional. So, he could be persuaded otherwise, I suppose. But I think that they had very legitimate concerns.
Now, I think that this rule does not violate the Fourth Amendment in 99.9% of its applications. Because although Carpenter and Jones carved out some, I think, still narrow exceptions to this general rule, there is, I think, a general rule that what someone does in public is not private. And most of the time, I suspect, when people fly drones, it's in public. And I'll even, for the sake of this, say that above your own tree line will count as in public. But there are going to be times where someone might not even leave the walls of their house, and they're flying a drone on their own property below the tree. And that drone and that person cannot be seen by anyone unless someone were to trespass on their property. In that instance, I think your rule is unconstitutional. Mm-hmm. What do you want me to write in an opinion if I get to write this?
My understanding is that the rulemaking would have to be done again, because the technical specifications associated with identifying very specific places in which the rule would not apply are things that would require substantial reworking of the rule itself. That's my understanding.
Would it? Or is it not that this is in effect a challenge to the rule's legitimacy, and you're saying that's an application that might be invalid? Sorry,
I'm trying to be candid with the court, Your Honor, just to say that
I'm grateful.
There's in the in the very small circumstances which you've identified, Judge Walker, that the FAA's application of the rule does not contemplate that sort of surgical tailoring, such that they would have to reevaluate how to implement the rule itself. That is my understanding based on my discussions with agency counsel.
So yeah, I think that was just kind of, I don't know, that's pretty clear to me. Like, you know, he very clearly says, like, if these are concerning, essentially what I get out of that as a non-lawyer is, if these are concerning situations that you continue to bring up and you feel like the rule should cover them, then we would need to go rewrite the rule and totally redo the framework to make the rule be able to take care of these situations. And there's no way to quickly handle that in the current rule.
Yeah, I mean, if you sum up that discussion, it seemed like the judge said, if it is constitutional, if it's not a Fourth Amendment violation in 99% of instances, but there's this 1%, then I would find it unconstitutional. And then the FAA lawyer said we could not take into account carving out surgical exemptions like that. Therefore, it sounds like they're both agreeing that the rule would be considered unconstitutional under the Fourth Amendment.
Yeah. One thing you were talking about earlier that I thought was pretty interesting, you know, we basically heard the two parts of this is whether, you know, either it kind of stays in the FAA's court and they'll have some jurisdiction over it with remote ID, our backyards and under the tree line, that sort of thing. Or there's a situation where they'll say the FAA doesn't have jurisdiction and then it'll kind of go to local and state. But I think you kind of said there's like another way they could say it where they say like, this is a privacy concern and then nobody would really have a right to that. Is that correct? Haven't really heard that perspective.
Right. So if it's a Fourth Amendment, so if the court finds that the government can't track you in your backyard the way this rule does, then the FAA wouldn't be able to do it and state and local government wouldn't be able to do it either. So unless they came up with a special needs exception. So let's say, you know, your property's next to a nuclear plant or next to something sensitive, then you might have the ability to require remote ID in certain locations. And
the FAA's response to that, or the DOJ's response to that, was that they didn't have the ability to sort of do that technically. But that kind of, I mean, that rings hollow to me. Like, whether something is a Fourth Amendment violation, it's a separate question from how hard or easy it is to do. That's the way it seems to me.
Yeah, I was surprised that he said that, but it may be that he wanted to make it harder for the judges to throw out the whole rule. So, I mean, you never know what's behind that. But I would assume that just like there's controlled airspace and you're required to get approval to fly in controlled airspace, there could be airspace that you're required to have remote ID. Now, sure, they can come back and say, well, the bad guys aren't going to have remote ID. Well, they're not going to have it anyway.
Right.
Yeah, this is something that's always bugged me about this particular rulemaking process, because so many other parts of the law, like you talk about having a license plate on a car, which we know is an imperfect analogy, but you could drive a car on private property with no license plate or registration. And if you drive it on the road, the public road, then you're breaking the law. And when you're caught, you're prosecuted. But the whole approach to remote ID has been to require everyone to have this technology and make it impossible for you to, rather than say, if you fly above 400 feet, then you need remote ID. They're like, well, we can't enforce that if we do that.
But it's almost like the whole reaction to drones has been from a fear perspective. So first it was a lot of fear mongering based on safety, which never really came to pass. And then there was a lot of fear mongering by the security agencies. And I think we all know that drones can be used for nefarious purposes, but the way to stop that is probably not remote ID, because that is not going to stop somebody with nefarious intent. You're just going to fly a drone without the remote ID. So it really, I mean, a lot of people call it security theater. All it does is, I think, affect law-abiding people, because people that aren't law-abiding aren't going to comply with it. I mean, I would rather see the FAA narrowly tailor the rule to really have a security impact, for example, to require remote ID in certain locations. But the concern is that the FAA was not willing to go forward with flights over people and beyond visual line of sight. So I wouldn't want a delay in the remote ID rule to mean that the future of drone use was completely stymied. So I would rather either that the FAA pushed back on the security agencies that were pushing it to require remote ID before it allowed flights over people, or that it finds a way to narrowly tailor the rules so it's not as burdensome.
Sure. One thing I wasn't clear on. So if they send back the final rule, if they say like, hey, this is unconstitutional, you need to take out these things that affect these backyards or whatever they do, how much can the rule change before they have to go through at least the comment period again?
Well, they would have to have a supplement. Yeah, okay. They have to go through the comment again. Right.
So they tack on, and then we do another comment period, and then they respond again, and that's the new final rule. Okay, gotcha.
Right. I mean, they could go to a direct final rule, but I don't think they would do that in this case. I mean, they could argue that they were ordered by the court, but I think the court would tell them to write a rule consistent with their decision, as opposed to telling them exactly what to write. I can't think of anything off the top of my head, but I think what it brings up is the importance of individuals coming forward. Because, I mean, I didn't like the rule, but I wasn't going to sue. So I'm happy that Tyler did, and I'm happy RDQ did, and I'm very happy with the attorneys that they hired. So if our rights are vindicated, it will be because somebody stood up.
Awesome. Well, that is absolutely true. It's as true now as it ever has been. Loretta, I really appreciate you taking the time to talk to us and giving us your insights and helping everybody understand this case a little better. So thank you so much.
You're welcome. Okay.
Awesome.
Thanks so much.
Bye-bye.
Bye, Loretta.
Bye.
All right. And Plenty, that's going to do it for you and me, I think. Appreciate you as well, man. You guys, I don't know where I am, and I don't know what's going to happen, but if I don't make it out of this, I just want to know that you subscribe to my channel, or maybe join my Patreon, or click one of these videos I picked out for you.